So now we're recording. So now everything that you say can be admissible, attorneys. So now you got to be careful. All right, let me turn. Let me find Robert and turn on your mic.
All right,
Robert,
Michael.
your mic should be live, and then I'll give you control.
Okay. Can you hear me?
I can hear you.
Great. So I'll get started then.
And you should have control.
Okay. So as Michael said, my name is Robert Rosing. I'm going to talk about a case called Timberlakes v. Cowan. And I am sorry to be the bearer of bad news. This is a make work for attorneys case. And I wish it were otherwise. I wish this case had come out a different way, but unfortunately it didn't. So if we get the next slide going, let's see. Oops. All right. So this case concerns the Timberlakes Association over in Wasatch County in the mountains. It's quite a large association. Everything just froze.
Are you frozen?
Yeah, can you hear me?
Yeah, I can hear you.
Okay, then I'll just keep talking. So this association is quite large. They have a lot of roads, and they own the roads. In 2012, some owners purchased a lot in the association, and they decided they wanted to build a freestanding garage. They did not receive approval from the association for this garage, although they claim that a couple of board members showed up at their lot and told them that it was okay. They put up the garage. The problem with the garage was that it was in the right-of-way for the road. It's just strange because, Michael, I can see you, but my screen is frozen.
We can see you, hear you, and see your slides.
Oh, fantastic. So in Timberlakes in particular, this is not an issue that I think most associations have, but the roads were not built well, and oftentimes they were not built in the right place. And this garage was built next to a road that needed to be fixed, needed to be moved, it needed to be built properly. And where the garage was located would interfere with the road. It would basically be in what is effectively the shoulder. And on a mountainous, large community with steep drops and steep curves, you want to have shoulders in case people have problems when they're driving. And this garage was in the way, and it was going to cause a big problem for fixing the road. So the association sued, and they sought a permanent injunction from these owners to remove and relocate the garage. Okay, since I'm frozen, I can't go to the next slide.
Permanent injunction slide?
Yeah, we'll go to my permanent, I'm going to go to my decision slide. So the lawsuit was litigated at the trial level, and the district court ruled for the association. So the association won the battle, but they lost the war. The district court said, yes, this garage was built in violation of the governing documents. This garage was built without approval. And the owner saying two board members coming to his lot and saying that they gave him approval, that's not enough. But then, even though they won that battle, they lost the war because the court said, but I'm not going to order the garage be removed. The garage gets to stay. So the whole point of the lawsuit, which was to get the garage removed, they didn't achieve that. And again, this is a big problem because now when they go to fix the road, they're going to have to move it, and they have to try and get permission from other people, and who knows if people will give them permission. Who knows how hard it's going to be to engineer. It's very expensive to engineer these roads. It's incredibly expensive to build them. So it's a big problem for the association, and they decide to appeal. The Court of Appeals, unfortunately for this association, upheld the trial court's ruling and said, we're not going to require that the garage be removed. And now we'll go back, Michael, to the permanent injunction slide. And this is the issue, and this is the reason I think this case is very important for community associations, because it's about permanent injunctions. And in case anybody doesn't know, a permanent injunction is an order of the court telling someone to do something. And if somebody builds a house where they're not supposed to build, if they build a house that's not approved, if they build if they expand their deck and it's not permitted, permanent injunctions are how you get a court to order whatever is not supposed to be there removed. And what the court said was that there's several requirements for permanent injunction, and the one that we usually look at that's usually an issue is called irreparable harm. And irreparable harm means harm that can't be compensated by money. You have to show that there's irreparable harm. And the association's issue at this level was that they didn't present evidence at the trial level about what the harm was. They didn't prosecute their case, and this is one of the reasons that I say it's a make work for lawyers. This is the minor reason. There's a major reason, but the minor reason is you have to show why something shouldn't be there. And it can't, it has to be more than just money. And in HOAs, usually we're trying to enforce governing documents, which are kind of nebulous, right? What's the value of not having a pink house in the middle of your neighborhood? It's hard to put a number on that. And the association got dinged for not adequately explaining why this was a problem. The other issue is that the court will do something called balancing the equities. And this is why I say this is a make work for attorneys, because when it comes to balancing the equities, which I believe is, my slide's a little bit out of order. It's the slide that says do not allow unapproved structures to be built. And this is the real takeaway from the case. This is the real make work for attorneys issue. Once something gets built, it is very hard to take it down because the court is going to balance the equities. They're going to look at, well, what's the cost and what's the benefit of giving this association whatever order they've asked for. In this case, we were asking for a structure to be removed. And the court would say, well, this guy put in all this time and money and expense, and we're going to make them tear down this garage. It's going to cost money. He's going to have to rebuild it. That's a big cost. And what is the association gaining? Well, in this case, they were gaining the ability to build their road properly. But in many associations, what you're gaining is the covenants will be enforced. We'll have a uniform plan of development. The houses will match. The neighborhood will look like it was planned correctly, which is usually what we want. But that's kind of a nebulous thing, and the court is going to weigh that against the cost of removing a completed structure. And so the reason that this is, again, a make work for attorneys case is that means if you figure out that someone is doing something they are not supposed to do, if you figure out especially if they are building something that they are not supposed to build, the association needs to act quickly to stop them from building before the structure, the room, the shed, whatever it is, goes up. Because once it's up, it's much harder to take it down. The deck is going to be stacked against you the further along somebody is in their construction. It's just a warning that you need to try and stop things. And unfortunately, the main way we stop things is we have to run into court. And we have to get a preliminary injunction or an early order that says stop. Stop doing whatever it is you're doing while we figure out whether you have permission or whether it's approved or not. The other thing in terms of balancing the equities is that it's important that the association come with clean hands to the table. You want to have followed your rules. You want to have been consistent in your enforcement. Because when you're not, and the court goes to balance the equities, the owner who is doing, in this case, something that owner shouldn't be doing, is going to point at all of the instances of unequal enforcement or of rushing through the rules or of rushing and not treating that owner fairly, and say, look, the equities, on the balance, this association should not be permitted to stop me from doing, again, whatever that owner is doing. And that, I think, is the most important takeaway, is simply that you have the association, unfortunately, I like to try and stop things with fines. If someone's doing something they're not supposed to do, it's much easier to fine them than to go sue them, right? Nobody wants to be filing lawsuits left and right. But the court seems to be saying, when it comes to construction, you do have to file a lawsuit. If you wait, you're risking not being able to ultimately win and get that thing removed, whatever it is. This was kind of an extreme case because this garage sat in a roadway, and the association had to rebuild a road, and that's it's potentially a huge cost to this association. And then again, the association perhaps did not put on enough evidence at the trial level of what the harm was. And so that's another make work for attorneys. The case has to be litigated properly. The one positive thing I would say that came out of this case was that, if you recall, I said the association won the battle but lost the war. The battle that they won was helpful because the owner in this instance said, 3 board members came to my house and they told me I could build this garage. This is a 9-member board. The governing documents are clear. The board can only act when it meets properly and takes a vote, or maybe votes by email, the way boards normally do. And the court ruled that the owner was not entitled to rely on one board member, basically said, even if that happened, owner, and they didn't rule about whether it did happen or not, but even if it did happen, even if 3 owners showed up and said, 3 board members showed up and said, yes, owner, you can build this garage, the owner should have known that he couldn't rely on that the governing document said it had to be a meeting of the board, and that a board member randomly showing up and giving him permission was not sufficient. So that's the one good thing that did, that one good principle I think that came out of this case was the affirmation that people are supposed to know what those governing documents say, and that you can't rely on a random board member when the board has to vote, because we get that all the time. So-and-so told me I could do it. Well, now we know that doesn't really matter. But that's it. That's my case.
That's okay. You willing to take a question or two of some of our 67 participants now?
Absolutely.
For you, Robert. Are you ready?
I just can't see them, so just read them out loud.
Well, we're going to turn on and let them ask them themselves. So, let's see. There might be one here in the chat. So the question is, how does a board make the trade-off of $10,000 to $20,000 in legal fees to file a lawsuit when we have ongoing and serious CC&R violations in our community?
So I guess I would make 2 points. One, if the violation is one that is not something permanent, like the construction of a home or construction, basically, we have some other options to enforce that don't require filing a lawsuit, and the easiest of those, or the one we go to the most often, are fines. And because of a change to the law now, fines might ultimately turn into a lawsuit, but hopefully that doesn't happen. So the first thing is fines instead of filing a lawsuit. The second thing is that I often tell boards that you do occasionally have to take a stand, and that if there's some egregious behavior, usually I find, be curious what Michael thinks, that if you really start cracking down and you do file a lawsuit and you let everybody know that has happened, which you're supposed to do, that can deter a lot of future behavior. So it's a large short-term investment for a hopeful long-term goal of decreasing the amount of violations. The other thing, obviously, is you want to have governing documents that allow for the recovery of attorney's fees in the case of a lawsuit, so that if you do have to sue somebody, you can hopefully get your attorney's fees back from them after you win. And if your governing documents don't provide for that, they can be changed, sometimes by a vote, usually by a vote of the owners, with an attorney helping you draft new documents.
Follow up on that. There's that they've imposed fines, the maximum fines, never pays the fines, goes in and out of bankruptcy for protection, and just is straight out ignoring stop work orders.
In that case, unfortunately, I think you really have little choice. The solution there is, unfortunately, to file a lawsuit and get a permanent injunction or a preliminary injunction, and then it doesn't matter whether he's in bankruptcy or she's in bankruptcy. The order just applies. It has nothing to do with money. It has to do with following the rules. And just so you understand, an injunction, a preliminary or permanent injunction, is enforced by the court, and if somebody violates it, they are in contempt of court, and the judge will use the tools necessary to ensure that the contempt stops, which can include putting somebody in jail. And so typically once we get the order, the violations stop.
If the garage had been approved by the association but was still put in the wrong place, would there have possibly been a different outcome?
If the garage had been approved by the association, but the owner, let's say in this case, knowingly said, I'm going to put it in the back of my lot, and instead he put it in the front of the lot, I think that in this case in particular, it probably would have come out the same way. But if the association had put on the right evidence, that would still be a violation, and the association still should have won, even though they did not.
Okay. All right. I'm going to turn on the Q&A really quick. We've got about 2 more minutes for Robert. So if you have a question, hit the Q&A button on your computer, and you can vocally ask your question of Robert. Otherwise, those were some great questions that came through the chat room. So looks like maybe people are going to be shy today. If you have a question, if we have some time at the end, we might open it back up for. And Robert, thank you. I'm going to go ahead and mute you till the end, and we're going to put Lincoln on.
I have to drop out and come back in, just so you know.
That's fine, sure. All right, so let me push all the buttons here. And get Lincoln's slides up on the screen. Lincoln Hobbs has been in the attorney business since 1986. Geez, I wasn't even born yet in 1986. So, licensed. Yeah, that's probably not a true statement. He's licensed in Utah, Idaho, and Wyoming. He's been doing the community association part of law since he started in '86. He's co-founder of the Utah chapter of the Community Associations Institute, and that's how Lincoln and I met for the first time, was at his first chapter meeting held in the restaurant at the Marriott up by the U, I believe, is where we were. So that was good time. Small group of us putting the chapter together. He's been on the national faculty since 2003 for CAI and has been a member of the College of Community Association Lawyers since 2004. He's past president of the Foundation for Community Association Research and of the College of Community Association Lawyers, and he currently serves as a trustee on the CAI National Board, helping the Institute in these precarious times and coming up with some great COVID policy and assistance. So, Lincoln, I'm going to go ahead here and see if we can successfully give you control of your slides, and if not, just tell me when to change them, but it looks like you should have control.
I think I do. Thank you. Thank you, everyone, for joining us. I'm going to talk today about a case I had nothing to do with. I stumbled upon it when it came down from the Supreme Court in April of this year. You can subscribe to advance reports so you get reported cases from the Court of Appeals in the Supreme Court. And this case came down, and of course, I saw it was a community association case. I read it. I thought it was rather fascinating for a number of aspects. A couple of things I want to talk about in this case. One is sort of the procedure of litigation a little bit for those of you who haven't had the excitement of being involved in a lawsuit, just how it works, how it doesn't work. And then we're going to talk a little bit about negligence and concepts that you should be aware of if you're a board member or managing an association. So the Cochidris case, I may or may not be pronouncing that right, involves an association out in Harriman called Rosecrest Village. It's an HOA. It's adjacent to Harriman City. It has park strips abutting roads. So those of you who are familiar with the concept, the park strip is actually owned by the city, often has vegetation, and oftentimes the association has responsibility for maintaining that, as they did in this case. Rosecrest Village did something very smart. They hired FCS Community Management as their community manager, and FCS was responsible for managing the association. Out in that parking strip, there was a rusted metal rod sticking out of the ground. The metal rod was not easy to see by most witnesses' accounts. You couldn't see it when the grass and vegetation was there. Ms. Cochidris tripped upon the metal rod, and after the fact, her mother-in-law, her father-in-law looked at it, and they noted that the metal rod was rusted. It looked like it had been hit with the blade of a lawnmower. It was disputed in the lower court, the district court, whether Rosecrest or FCS had mowed the park strip at the location of the protruding metal rod. Some people had suggested that the Harriman City undertook that responsibility. Some people said it was FCS, but this case never really did get through the discovery process. So that fact was never established in the trial court below. The Harriman ordinances, though, provide it shall be the duty of each owner of real property to repair and maintain in good condition all park strips across or immediately abutting their property. So typically, even though the city will own the first portion of the road portion of a person's property, the person will maintain that property, and it is their responsibility to take care of it and keep it safe. The metal rod, after the accident happened, was determined to be a part of Harriman City's streetlight infrastructure. It was essentially a grounding rod to ground the lights fixtures, but it was a jutting from the ground. Ms. Cochidris, after she tripped, sued Harriman City, Rosecrest Village, HOA, and FCS. One of the first things that you should learn about litigation is that a plaintiff's lawyer is going to sue everyone they can think of who might have liability. So they sued Harriman City because Harriman City owned the property. They sued Rosecrest Village because Rosecrest Village was adjacent to the property and arguably had the statutory duty to maintain. And FCS was, of course, the entity hired by Rosecrest to manage the association. So they sued all of these people. In the district court, after I read the appellate opinion and began preparing this, I looked at that. The case was filed back in January of 2014. Not much happened in this case. The parties did conduct some depositions, but ultimately the court brought an order to show cause because the case was not being pursued. So the defendant's counsel then brought what's called a motion for summary judgment, saying that there's no basis for liability here. None of the defendants did anything wrong. The summary judgment standard, in order to win a summary judgment, you have to be able to establish that there is no genuine dispute as to any material fact, and the moving party is entitled to judgment as a matter of law. Those of you who have been in litigation oftentimes will say there's no merit to this case, get rid of it, get it dismissed. And there's an expectation that a lawyer can just roll into court and get a case dismissed either at the outset because it has no merit or even down the road. Unfortunately, summary judgments are very difficult to get because if there's any factual issue at all, anything that the jury could find that would warrant a decision on behalf of the plaintiff, the court should deny the motion. But in this case, based upon the evidence before it, the court thought that there was insufficient evidence that the association, the city, or FCS knew or should have known of this metal rod. And if they didn't know of the metal rod, they didn't have any duty to the owner or the woman who tripped to do anything about it. The case went up to the Supreme Court, which is, of course, where appeals go. They can go to one of two appellate courts. When you appeal a case, depending on the nature of what you're appealing, there is a standard of review. If you go through a jury trial and you try to appeal a case, it is very, very hard to prevail because the Supreme Court is going to assume all of the facts were decided properly, and they're not going to second guess the finding of facts. But when you have a summary judgment, the standard of review is very, very tough because the Supreme Court or the Court of Appeals is going to believe that they are just as capable of determining whether or not the court was right on the law, their legal conclusions right. So they will review those legal conclusions for correctness. If they think they're wrong, they'll reverse them. So in this case, they did a very careful review, and another standard that they look at is whether reasonable jurors, properly instructed, would be able to come to only one conclusion, or if they might come to different conclusions, thereby making summary judgment inappropriate. So if the appellate court believes that a juror, properly being told of the law, could have found one of these defendants responsible, the case should be reversed. So the Supreme Court then looked into two issues that arise anytime you have a trip and fall or a slip and fall or something arising from an unsafe condition. They analyzed two different conditions. There are temporary unsafe conditions, which the court defined as things such as a slippery substance on the floor. Usually it is not known how it got there. This is the water in the produce aisle, the grape in the produce aisle, the thing in the grocery store that gets spilled and they don't clean it up quickly enough. These cases are hard to prove because you have to be able to prove where it came from, who was responsible, should the store have done anything about it. The next thing you need to have when there is a temporary condition is you need to show that the defendant knew about the dangerous condition, and that they had sufficient time such that in the exercise of reasonable care, the defendant should have remedied the dangerous condition. This is why it's very difficult for plaintiffs' lawyers to bring slip and fall cases against grocery stores, because they have to show that the water was on the floor or the grape was on the floor long enough that the store knew about it, could have cleaned about it before somebody slipped and fell. And oftentimes that can't be discovered. This is somewhat the condition you have when you have ice and snow conditions. If you have a slip and fall in an ice or snow condition, one of the things the court's going to look at is how long ago did the snow fall? Was it reasonable for the snow removal company to be able to get out there and get salt down? If you have a slip and fall on ice that occurs right after a storm, you're probably not liable. If it's 24 hours later, you're more likely to be liable. And that's the aspect of the ability to remedy the dangerous condition. The Supreme Court also looked into permanent unsafe conditions, which are those things where in the structure of a building or a stairway, in equipment manufacturing or its manner or use, which was created or chosen by the defendant for which he is responsible. So if there's something that's there that's been there a long time, the showing of fault is much less standard, because if the defendant created the condition, is responsible for it, he's deemed to know of the condition, and no further proof of notice is necessary. So if you can establish, if you could have in this case established that Rosecrest was responsible for that rod being there, it would have been much easier to bring a claim against them. It was a little bit nuanced here because it was Harriman City's rod. Rosecrest had the responsibility to maintain. So the plaintiff's lawyer in this case, for reasons that are kind of hard to analyze after the fact, argued in the case below that this was a temporary condition. They didn't even argue that this was a permanent condition, that it had been there a long time. So the court didn't analyze it as the court below didn't analyze it as a temporary condition. They got to the Supreme Court and they said, well, it's a permanent condition. That was a big mistake on the counsel's part not to raise the permanent condition down below, because one of the things about appellate arguments is if you don't raise an issue down below, the appellate court's not going to hear it. So because they had argued in the court below it was a temporary condition, they couldn't argue it was a permanent condition in the court above. Hope everybody's caught that. I'm kind of moving quickly because I found as I looked into this case, I could have spent an hour on it. But the simple matter is that they would have gone in and said, that metal rod was there, it was rusted, it had lawnmower marks on it, it had been there a long time, it probably would have been easier for them probably to get past summary judgment, and they could have raised the issue at the Court of Appeals, or the appellate court. But the Supreme Court said, you didn't argue this below, we're not even going to consider it because it's unfair for the trial court judge and judicial economy to allow somebody to come up with a better argument that didn't present in the trial court. So this is more of a thing that lawyers should be aware of rather than parties. But if you've got arguments that are good arguments, you need to think about them in trial. And you need to raise them in the trial court so that the trial court can consider them, because otherwise the appellate courts won't do that. The Supreme Court just said, we're not going to deal with whether or not this is a permanent condition. But they did proceed to establish whether or not it was a temporary, they did conduct a temporary condition analysis. So what they had to find in that circumstance was that Rosecrest and or FCS had knowledge of the metal rod and sufficient time to do something about it. Again, they tried to argue the plaintiffs tried to argue at the appellate court that they had actual knowledge about it. But again, the Supreme Court said you don't get to do that because you didn't do that below. So they had a couple of good arguments that they could have raised in the district court that had they done so, the district court might have denied the motion for summary judgment. They would not have spent 2.5 years at the appellate court, or 2.5 years plus, getting this determined. But ultimately, they were required to prove constructive knowledge. They had to prove that Harriman City, FCS, and or Rosecrest knew or should have known about this condition. They had to show it had existed long enough that they should have discovered it. They ultimately argued at the appellate court that the facts viewed in the light most favorable to the party opposing the motion, that is the city, the association, and FCS, established that the metal rod was a prominent condition in a residential, regularly maintained park strip. The dispute about its visibility was viewed in a light most favorable to the plaintiff. Some people said you couldn't see it. The mother-in-law who was walking with the plaintiff said she saw it right after the daughter tripped. Of course, if that evidence comes in, then the argument is the person mowing the lawn should have seen it every week when they mowed the lawn. In the summer, would have been more visible in the winter. Hence, there should have been knowledge. Court held it was reasonable to infer it was prominently poised when it was mowed. And a jury could reasonably infer from the durable, non-transitory nature of the metal rod that it existed from a significant period of time. It had been there as long as the lights had been there. So then the court got to a duty. The court said, okay, you knew or should have known about this. Who had a duty to do something about the fact that this rod was there and presented a tripping hazard? Everybody at this point in time, the district court hadn't analyzed this question because they just tossed it out based upon the lack of knowledge. So the duty arguments were all presented anew at the court. FCS and Rosecrest acknowledged that they had the statutory duty to maintain the park strip if they were called upon to do it. But there was actually a dispute as to whether or not they could have or should have removed the grounding rod because that was Harriman City's streetlight infrastructure. The court said if they knew of that issue or that rod, they didn't necessarily need to repair the streetlight. They could have told Harriman City about it, which would have absolved them of their duty and put the duty to FCS. Harriman City said we didn't know about it, so Harriman City stayed in it as well. So what the court did after all of this was they remanded the case. They sent it back to the trial court and told the trial court that it needs to deal with these factual issues, it needs to deal with the duty, it needs to deal with what FCS knew or should have known, it needs to deal with what Harriman City knew or should have known. So it was sent back to the district court for further proceedings. There's actually a pretrial set for next week, meaning that there will be a web conference because we don't have court anymore. There'll be a web conference where the lawyers will talk about how they're going to get this case done. As I mentioned before, they didn't do much before it went on appeal, so they'll figure out what discovery is going to be conducted, what depositions are going to be taken, what evidence will be there. That discovery will last some period of time, and ultimately there may very well be a trial. The reality is there probably won't be a trial because most of these cases settle. A few takeaways from the court, from what this brings about. Dispositive motions are tough to win. Don't think that just because the plaintiff is crazy or you know that the plaintiff is a liar, that your lawyer should be able to get this out, because even if the plaintiff's testimony is not believable, if it's admissible, they're going to get in front of a jury. Lawyers should be very careful to preserve the record on appeal. They need to make all the arguments down below that they want to raise on appeal. And sometimes you make arguments anticipating that a particular judge or jury isn't going to accept them, but you want to be able to raise them on appeal. And again, if you don't do it, you're not going to raise it on appeal. Permanent unsafe conditions must be remedied. Even if you, as an association, don't own the property, if you become aware of something, on or adjacent to your property, you need to get it fixed. Temporary conditions also need to be remedied, and you need to use reasonable efforts to do so if you can. If you find out that there is something on your property, you should get it cleared up. And lastly, liability may extend beyond your property. Rosecrest is being sued for a condition that existed outside of their property. They argued that they didn't have the right to remedy this, but they're still being sued for it. And that's an important thing to keep in mind, because liability doesn't always tie to ownership. One last slide I've added here, and I think Michael will be distributing these so you can get this language, and you can get the case if you want to look it up. There's a case that was decided back in Georgia in 2006, and there are a number of cases that have followed this. And in that case, the association put language in their declaration, which if you read the last sentence of this, it shall be the affirmative duty and responsibility of each parcel owner and user of the common area facilities to continuously inspect. So owners have a duty to continuously inspect themselves the conditions of the common area, and if they see something that is problematic in the common areas, they need to bring it to the board's attention. I put this in the declarations that I draft now, and I often add it when I amend declarations, because although the Utah courts have not yet adopted it, a number of courts in various states have said, if you impose upon your owners the duty to watch the common areas, their duty can be equal to that with the board. And if they become aware of a condition, they need to let you know about it. So that can give you some protection against lawsuits, at least from your own owners. Those are my takeaways on this case that I could have spent an hour on.
Well, thank you,
and
Lincoln.
Michael's going to spend a few more years on.
Yeah, well, you know, I learned to get a thick skin a long time in this industry, and I don't take it personally. Is there? I don't see any questions in the chat, and I know Bruce is chomping to go. My one question would be, I've asked this question of the attorneys involved, is where does the landscaper who, according to the lawsuit, hit the rod and may have been the only one who knew the rod was there, does the association need to get their counsel to bring the landscaper into the lawsuit?
My reaction to that is probably that person may have had some fault, but they had fault many, many years ago, at least 6.5 years ago, because this case has gone on for 6.5 years. So they're probably out based upon the fact that nobody brought a lawsuit within statute of limitations, and they're probably protected merely by the lapse of time.
Yeah, yeah. All right. Well, Lincoln, hang on to the end. We might have a couple questions. We appreciate that. Let's roll on over to Bruce here. And Bruce, give me just a second to get you set up. So and let's see, Bruce, let me unmute you. There, we can hear you now, and let me pop up your slides, and you should have control.
Very good. Let me, can you hear me, Michael?
Yes. So, oh, sorry, I forgot to properly introduce Bruce. Let me do that real quick. Bruce has been working with associations and association law since 1991 and is one of Jenkins Bagley's founding members. His practice focuses on association law, real estate, land use, construction defects, municipal business, and civil litigation. He's a member of the federal, state, and local bar, a member of CAI, of course, and the Southern Utah subchapter of CAI. And he is the current chair of the Legislative Action Committee, which is nice because I was the previous chair, so it's nice to have someone else taking that on. In 2012, Bruce was inducted into the College of Community Association Lawyers, and I know Bruce is very involved in doing his own continuing education of board members and community managers down in southern Utah. And just like all of us, he's put that into the virtual world as well. And so Bruce is going to send us some of his invites of his future monthly education sessions that we can then forward out to all of our board members to possibly attend those too. So Bruce, thank you very much for joining us, and you now should have control.
Great, thanks. So let me go to the next slide. Let's see. Should go to the next slide.
Can you hit the down arrow?
I hit the down arrow.
There you go now. There it goes. It's caught up.
Did it catch up?
Backstory now. There we go.
Yeah, let me go back a little bit. So I'm going to give you some backstory. In my case that I'm going to talk about has more anecdotal benefits than maybe hardline case summaries. But initially, a board member and a member in the community were friends. They enjoyed activities together, and at some point there was a falling out, and that friendship was lost. Let's see. Is it slow to catch up, Michael? I'm sorry. My next
It does seem to be a little choppy. I'll get it caught up for you.
Okay.
Maybe.
Maybe. If not, I'll just talk about it anyway.
There we go. Falling out.
Falling out. And then there was a murdered cat. I'll show you about that because what happens is the case became personal. It wasn't just any longer about the association problems. So the real issue in this case was there was an alleged rental violation, but there was no restriction on rentals in the CC&Rs. So how do you have a rental violation with no restrictions on rentals? Well, this association required that every lot was occupied by a single family residence. And on this property, the owner had her primary home as well as a detached casita. And she rented out the casita. So now there were two families on this single family lot. And by the way, when this owner got approval from the city for her casita, in the minutes of that approval, of the minutes of the city, they informed her that she could not rent out her casita independent of her home, but she did it anyway. So the association did what Robert Rosing said, they fined. Well, the fines didn't deter the action. She was committed to continue renting and thought she was right. At some point, she alleged that there was fraud. And one of the takeaways we'll talk about at the end, there were other people. There were people behind the scenes championing on this lady because the issue seemed to them to be larger than just rental issues. So the cat. This is the owner's cat, at least while it was intact. If you are quick enough to read the screen, you'll see that she's offering a reward because someone had taken that cat, surgically cut it nearly in half, drained its blood, removed its heart and lungs, and this lady thought that her friend board member had done it. Not to be too graphic, but that's a picture of the cat. Some people were saying a coyote got to it. I don't think that a coyote got to it, but I also don't believe it was the board member, despite what the owner suggested. There was a police investigation. The police couldn't conclude anything. So this picture, it's not that exact community, but it's a little bit representative. You see a house on the left and then an independent casita on the right. And under Utah law, a couple of older cases, a Brown versus Gee case and some others, basically stand for the proposition that if you have a single family residence requirement in your governing documents, it doesn't only limit the kind of structure, it limits the kind of use. So if you have two families living on one lot and you should only have one family, then there's an alleged violation of the documents. And so that's what the association sued upon. They claimed that this should only be a single family, and they wanted to collect the fines they had levied, about $100,000 in fines over time and some fees. The owner, however, as often happens in lawsuits, is she wanted to level the playing field. So she brought counterclaims. She claimed that there was a breach of the fiduciary duty of the association board members, that they weren't properly administering the CC&Rs, that the CC&Rs did not prohibit rentals. Therefore, their act in bringing a suit against her to restrict her rentals was a violation of their duty. Again, it wasn't so much that she was renting, it's that she caused a second family to live upon the premises. Then the association claimed selective enforcement, and Robert Rosing talked a little bit earlier about that, how you need to be consistent. In this situation, the association was entirely consistent when enforcing actions where a casita was separately rented to a separate family. In fact, she was the first, so they were consistent. That was the only time they had to do it. However, other homes had been rented out. In-laws had moved in with families, and so the claim was the association was not consistent. Now, going back to what Lincoln said, even if you are consistent, if someone claims you are not, you may still be stuck in the lawsuit for quite some time, because if it has to be the judge weighing the evidence and decide who's more credible, that can only happen at trial. It can't happen before. And she also wanted specific performance, basically having the judge tell the association that they must allow her casita to be occupied by a second family and therefore rented. So, case history, it took 4 years of litigation. Never even got to trial. The HOA actually did win on a motion for summary judgment. The court found that she was in violation, that she had a second family occupying the premises in violation of the CC&Rs. However, the court reserved for trial to determine whether there was any selective enforcement, and if so, he might, if you will, reverse his finding on violations, or at least find that she was excused from violating because the association had selectively enforced. We never got to that. I think she would have lost on that. However, the case did not end, kind of like Robert Rosing's case. It didn't end simply because we won at summary judgment. Other issues were still there to be litigated. The case ultimately settled. Insurance stepped in, was willing to pay some money. However, as I mentioned before, there were others involved in this case, not just the plaintiff, others behind the scene. Those others behind the scene started to feed information to Ms. Teresa's attorney. They fed that information to her attorney anonymously. They wouldn't put return address on their information. They just sent stuff, and they suggested that the settlement had been entered into fraudulently, that the association board members had misled Mrs. Teresa into entering into the settlement agreement, that they had withheld information, and as it turned out, some of those individuals were also helping pay her legal fees. So she changes attorneys, sues to set aside the settlement agreement, and we have now round 2 because there was an allegation of fraud. Ultimately, she could not prove there was fraud because she would have to prove that she had reasonably relied upon a misstatement by the board to her detriment. Now, I left out several elements, but that's the basic idea. She would have to relied upon their representations when she settled and would have done so to her detriment. As the facts turned out, she thought they were liars from day one. Her testimony was riddled with the fact she never believed anything the board said. So she couldn't prove that she had reasonably relied upon any statement of the board that caused her to settle. Rather, the court found that she never believed any of them. The court, however, did split the baby a little bit and found that some of the board member statements weren't, in his view, entirely accurate or forthcoming. So it just drug the litigation on. Again, 4 years, not even a trial, and a lot of money was spent. She also filed an appeal, wanting to have the Court of Appeals determine whether or not she was fraudulently induced to settle or not. Ultimately, though, before the appeal was realized, she did settle. So let's go down to Michael. I seem to have a delay again. I want to go to the takeaways. So they did finally settle. Oh, for the takeaways, yeah, champions. Thank you for that slide. Again, there were maybe half a dozen people behind her trying to do that. Beware of fraud. It's just, you might get challenged, and no matter what you say, someone's going to see it differently, and they might claim you to be a liar, therefore fraud. Money pit. I'll explain this a little bit more later, but litigation is a money pit. Both sides, although some of the association's expenses were covered by insurance, both sides in this case spent in excess of $100,000 litigating the issue of, could you occupy the casita on your single family residence lot? A crazy amount of money was spent. So what are the takeaways? First, for the benefit of the associations, if you have a single family residence requirement and you have two families occupying the property concurrently, then that would be considered a violation of the CCNRs, notwithstanding any rental restrictions. In an outside chance, you might even be able to use this if someone is renting a portion of their home on a nightly rental basis and you want another reason to challenge that. Again, single family residents might do that. But it's usually, you have to consider, well, this works best if there's two structures on the property and one is occupied by one family and a completely separate structure is occupied by another, or the basement is completely occupied by another family. It works best in those situations. Beware when the issue becomes personal. I showed you the cat. That cat instance occurred before the lawsuit, but it became a topic throughout the lawsuit, even though it was not in any allegations in the case. Anytime we tried to settle, the cat became an issue and we could never settle. Reminder to be consistent in your enforcement. And again, when there's others behind the scenes, I've had this in at least 3 cases recently now where, in fact, one case I showed up to mediation with another party, and when I got to mediation, there were 12 additional people in the other room with the lot owner. And I said to the attorney, hey, I'm not negotiating with 13 people. I thought I was negotiating a settlement with 1. And he said, well, these people are interested as well, so we thought we'd invite them all along. And for a few reasons, we decided to continue on with the mediation, which ultimately failed. But just know that if you have others championing the cause of the lot owner, it's going to be difficult to settle, because how do you settle with a committee? You might be able to settle with a person, but you might not be able to settle with all persons. And so it never settles. And litigation is or can be a money pit. I tell even my own clients, if an attorney tells you, even myself, that you have a good legal argument, that's a code word or code phrase. What they're really telling you is get prepared to spend a lot of money, because the other side will have a good legal argument, they think, and it just takes a lot of money to argue. So that's my summary. Again, anecdotally, beware when it becomes personal. Beware when others are involved. And though it's not on the slide, I would also say this. In some of my nastiest homeowner association litigation cases, the lot owner has no family to leave any inheritance to, and so they feel just fine burning their money fighting against the HOA because they've got no one else to give it to. Anyway, thanks, Michael.
Thank you, Bruce. All right, so let's see if we've got any questions out there. I do see one in the chat room. I know we're running a little long this week, but I thought those were some great summaries. So let me, if computer's tired too and slightly disturbed by your murdered cat picture, Bruce. So it's good thing it's a virtual lunch, because I would have lost it. I virtually lost my lunch. Here's a question that might be, and I'm going to turn on everyone's mics. Lincoln, your mic, and let's see if Robert, probably down, he's down at the bottom of my list now, so he came back in. There he is. So Robert. All right, so any of the three of you want to jump in. The question is, new construction zoned, single-family owner built 2 apartments with separate entrances in basement while the builder controlled the HOA. No evidence that permits were ever obtained, although the owner said the city said that it was okay. Owners take control of the association, become aware of the apartment issue based on parking issues, and raised CC&Rs had vague wording restricting whether or not separate dwellings, sheds, etc., basements, garages. City has not enforced the zoning. Where should an association go from there? Bruce, I'll throw that to you.
Okay, so it's a tough question because it's there, and it's going to take, if anything, a lawsuit to get rid of it, unless the people are willing to just abandon their duplex, which is not likely to happen.
This is enchiladas.
Can you?
Okay.
The case of Brown versus Gee, and there's another one, Holiday Duplex, that are helpful to you, and in part they would say that you can't build an improvement that is otherwise in violation of the CC&Rs. I guess what I'm saying is that it would be the ultra vires act for the builder to approve the duplex. So that approval should be big. However, you have the equity problem. The only way you're going to resolve it, I think, is a lawsuit to claim that it is in violation and rely upon, again, Brown versus Gee and Holiday Duplex.
Okay. I'm seeing reports that the screen's frozen for everybody, but everyone can still hear us. So hopefully it's frozen on, our best look. Another question's come in. Does consistent enforcement in a case cross over to inconsistent enforcement of rules not related to the particular case? Lincoln, do you want a shot at that one, Lincoln? Does consistent enforcement in a case cross over to inconsistent enforcement of rules not related to the particular case?
So I guess the question is, if you enforce a rule that's being challenged, is it relevant that you don't enforce other rules?
Yeah, I think so.
That would be, I would think that if you are enforcing a rule in question and you seek to enforce that rule, the lack of enforcement of other rules should be irrelevant. However, Bruce's partner is very familiar with a case in which the court disagreed with my opinion. So it goes to the question of, different viewpoints.
Right. Robert, you on there? Do you want any comments on that?
Can you hear me?
We can hear you.
Okay. I would say it goes to the question of whether the enforcement is arbitrary and capricious. They shouldn't necessarily be related, but if an owner can show that you're being consistent in one circumstance and being inconsistent in another circumstance, and can spin that or can use it depending on which side of the fight you're on to show that, you know, they're picking on me, because that's the claim. We don't want our enforcement to be arbitrary and capricious. We don't want an owner to be able to say they're picking on me. See, they're enforcing all those other rules fairly. When it comes to this rule, which is the only one that matters to me, they're inconsistent. And I think I think you can go to that argument about arbitrary and capricious enforcement.
Good. Well, as everyone can see, there are always, new question just popped up last minute. Okay, we'll do this last question, and then I got to let these attorneys go make their money. HOA is governed by home builder and builders. HOA is governed by the homeowners, and builders build on empty lots that are zoned to be townhomes. What can the HOA do to hold the builder responsible to build correctly before the townhome exteriors are turned over to the HOA? Bruce.
Another great question. The association is not typically in contract with the builder. They're in contract through the CCNRs with the owner. If you want to be in control of that, you almost have to require that the builder of the townhomes, the owner of the lot that the townhome is being built on, that owner has to have an approved builder. And then you can get in contract with the contractor by saying HOA approves this builder to build, and he must build according to these terms. If he violates it, he's in breach. Otherwise, it's the owner that has the problem unit, and you have to bring your claim against the owner because you don't have a direct claim against the contractor.
Unless possibly maybe the contractor could be the owner of the lot.
If the contractor is the owner of the lot, then you've got one and the same, and you can bring that action against them.
Okay. Thank you, gentlemen, for your presentations today and for the time to put these together. We had 71 people join us. That's our highest attended. Everyone loves you attorneys, man. I just don't understand how come when the community managers say they need to go get some legal counsel, no one wants to love you guys then. But when you're free, we're all over it. So thank you very much for joining us. Reminder, next month, the last Tuesday at noon, understanding the property coverage of your insurance policies. We appreciate everyone for joining us today, and we ask that you stay safe, Utah. Wear a mask. Let's get this thing over with so that we can get together again someday. Thank you.
Thank you.
Thank you.
Thank you.